Welcome to the University of Chicago, the University of Chicago Law School, and this conference on the Bill of Rights and the welfare state. As you know, this conference celebrates both the centennial of our university and the bicentennial of our Bill of Rights. At the time this university was founded, William Rainey Harper, its first president, explained that although many will deny that democracy has a religion, none will deny that democracy has a philosopher. The university, he said, is the philosopher of democracy. To fulfill this vision of the university, our law school will host a series of centennial conferences this year, each of which is designed to help us, students, faculty, alumni, and friends, better to understand our legal culture and the broader society of which it is a part. For this centennial conference on the Bill of Rights, which has been made possible by a very gracious and generous grant from the Robert J. Cutak Foundation, we've assembled an extraordinary collection of scholars to address some of the most important constitutional issues of our day. Indeed, one might say that we have assembled for this conference the most talented collection of constitutional theorists since the framers themselves met in constitutional conventions. One might say that. Or, to paraphrase John Kennedy, one might say that since James Madison dined alone. Madison, of course, was the framer, the architect of the Bill of Rights. But he himself was less than confident that his list of guarantees really would make a difference. As Madison wrote to Jefferson in 1788, experience proves the inefficacy of the Bill of Rights on those occasions when its control is most needed, offering as illustration repeated violations of these parchment barriers committed by overbearing majorities whenever circumstances allow. Nonetheless, when Madison presented his proposed bill to Congress, he offered two arguments for the proposition, or at least the hope, that the Bill of Rights would matter. First, Madison predicted that his list of guarantees would be treasured by the judiciary, that those independent tribunals of justice would consider themselves the guardians of these rights, and that the courts would serve as an impenetrable bulwark against every unwarranted assumption of power. What Edmund Burke believed about a free people, Madison believed about the courts, that they would sniff the approach of tyranny in every tainted breeze, and that they would be naturally led to resist every encroachment upon rights expressly stipulated for in the Constitution. Second, Madison believed that the enactment of a Bill of Rights would serve an essential educational function in a self-governing society, predicting that the political truths declared in the Bill of Rights would acquire the character of fundamental maxims of free government, and, as they became incorporated with the national sentiment, would counteract the principles of interest and passion. In this conference, we can and will ask whether the Supreme Court of the United States has met its constitutional responsibility to protect and to preserve the rights and liberties of our people. And in so doing, we will take a step towards meeting our own special responsibility to promote an enlightened public understanding of our constitutional past and future. It is, I think, noteworthy that 100 years ago, there were few, if any, celebrations of the centennial of our Bill of Rights, whereas today we are inundated with seemingly endless conferences, symposia, and debates celebrating its bicentennial. This is so because in its first 100 years, the Bill of Rights played only a minor role in our constitutional system and our national consciousness. Indeed, it was not until the Supreme Court's Incorporation decisions of the 1930s and 40s and the consequent extension of the Bill of Rights to the states that Madison's guarantees finally emerged as a central and defining theme of our national life. Thus, in a very real sense, the Bill of Rights that we celebrate today is as much the product of the judicial doctrine of incorporation as it is of the foresight and wisdom of the framers themselves. Well, my assignment this afternoon is not to speculate about the Bill of Rights. It is instead to introduce the individual who will introduce the individual who will speak. I remember when I was a professor. In those days, I often was invited to speak myself. When I became a dean, I found that I was asked not to speak, but to comment on the speech of others. As the years passed, I found that I increasingly was asked not to comment on the speech of others, but to introduce the speaker. Today, I introduce the person who will introduce the person who will speak. I fear that next I will be invited to set up the microphone. On this occasion, however, and perhaps only on this occasion, I am truly honored to introduce the person who will introduce the speaker. The University of Chicago Law School has been graced throughout its history with a remarkable succession of constitutional law scholars, including James Parker Hall, William Winslow Crosky, Harry Calvin, Gerhard Casper, David Curry, Antonin Scalia, Richard Epstein, Cass Sunstein, Mike McConnell, David Strauss, and others too numerous to mention. It is not open to argument, however, even at this institution, which so loves to argue, that preeminent among these constitutional scholars is Philip Kurland, the William R. Kennan Distinguished Service Professor of Constitutional Law. Phil was the founder and editor for almost 30 years of the Supreme Court Review. He's the author of more than 20 books, including Politics, the Constitution, and the Warren Court, Mr. Justice Frankfurter and the Constitution, Watergate and the Constitution, Religion and the Law, and the Founders' Constitution. And he has published more than 200 scholarly articles. Phil is truly one of the most distinguished and most influential scholars in the history of American constitutional law. Phil also played a pivotal role in the intellectual life of our law school, and he has served as mentor to many aspiring colleagues over the years. Let me tell you a story to illustrate the point. Shortly after I joined the faculty with my own former law clerk's rather wide-eyed interest in constitutional law, I was assigned the office next to Phil's. Phil was and is a daunting figure, and I was more than a little intimidated to be in such close proximity to the Professor Kurland. On the day I moved into my office, Phil stopped by and asked if I would do him a favor. I, of course, agreed, though I had no idea what he might possibly have in mind. Phil explained that he had some books in his office that were cluttering his shelves, and he asked if he could have them moved into my new office. Frankly, I was astonished that he would make so intrusive a request, but having already agreed, I of course said, no problem. When I returned to my office the following morning, I found on my shelves the entire set of the United States reports, the most prized possession of any constitutional scholar in the pre-Lexis world. It was Phil's way of welcoming me. Phil, I can never return that favor, or more important, that vote of confidence. But it is my pleasure this afternoon to invite you to present the keynote speaker at the University of Chicago Law School's one and only in all of history Centennial Conference on the bicentennial of the Bill of Rights. Phil Kurland.
Jeff's kindness has made it impossible for me to provide an adequate introduction to our speaker. But I can top him in one way. He has failed to tell us that our speaker's wife is with us today, and I'd like to acknowledge the presence of Mrs. Stevens and to thank her for coming. Thank you, Mrs. Stevens. I spent my entire life in academia, and in all this time, I could be sure of but two truths that have emerged. First is that old saw that there's no such thing as a free meal or a free speech. The second is an intuition of my own, based on long experience, that the more certain it is that the principal speaker, quote, needs no introduction, the likelier that the introduction will be a long one. Our speaker this afternoon is and has been for more than 15 years a Justice of the Supreme Court of the United States. You all know or have heard about John Paul Stevens. He needs no introduction. So let me tell you about it. First, there are two blots on his escutcheon. First, although a Hyde Parker, born and bred, and a 1941 alumnus of the College of the University of Chicago. He took his law degree at Northwestern. Second, he clerked at the Supreme Court of the United States for, and I trust my faculty colleagues will excuse the expression, under the circumstances, a liberal justice, Wiley Rutledge. In our war, Stevens and Churchill's, Stevens earned the Bronze Star as a naval officer. After the Navy and law school, he practiced law in Chicago, first with the firm that has become Jenner and Block, and then with his own firm of Rothschild, Stevens, Barry, and Myers, with some time off to act as counsel to a House of Representatives committee studying monopoly power, because antitrust law was his specialty during his years of practice. He later was counsel to a commission to investigate some hanky-panky on the Supreme Court of Illinois, resulting in the resignation of 2 justices of that court. Of course, he was a good citizen on the bar associations, but he took an appointment as judge for the United States Court of Appeals for the Seventh Circuit in 1970, just in time to avoid becoming president of the Chicago Bar Association. In 1975, Edward Levy was trying to clean up the act at the Department of Justice after the Nixon debacle, and Judge Stevens was, as they say, elevated to the Supreme Court, Vice William O. Douglas. I would comment on 2 almost unique qualities of John Paul Stevens. The first is that he is a modest person, which is indeed rare among federal judges. Almost as rare as among law professors. Parenthetically, I ask you to review in your mind the televised hearings of Rehnquist and Scalia and Bork and Kennedy and Souter and Thomas, judges all, and ask how many would qualify as modest. The second point I would make is that Stevens is one of the few on the High Court now who, in the words of Oliver Wendell Holmes, Jr., quote, flocks alone. He belongs to no crowd. For him, the role of a justice of the Supreme Court seems to be the exercise of judgment based on reason and not force or will. Of his faults, and I want to speak of that too, one can certainly say he sometimes uses too many words in his opinions. It is a worthy heritage of Brandeis and Frankfurter and Rutledge and Stone, and you must remember that he has the appetites of 2 law clerks to satisfy. Aside from the fact that he is a bridge addict, as well as a life master, I have told you all that I shall tell you about him. It is a pleasure and an honor to present to you Mr. Justice John Paul Stevens.
Thank you very much. Thank you, Phil, Dean Stone, fellow judges, friends of the University of Chicago, Senator Ruska, and I see a number of other familiar faces from many years back, from even back when we were in high school. George Bogert, Wally Blum, there are a lot of old friends here, and it's very moving occasion to be here after leaving the college some 50 years ago. In an otherwise mundane tax opinion, construing language in the Internal Revenue Code, Oliver Wendell Holmes observed that a word is the skin of a living thought. As the years pass, an idea may mature, changing its shape, its power, and its complexion, even while the symbols that identify it remain constant. There is a special vitality in words like commerce, equality, and liberty. In southwestern England, the huge Sarsen pillars that primitive astronomers erected and arranged at Stonehenge centuries ago convey a profound message about man's ability to learn and to create. Even though the intent of the framers of Stonehenge is shrouded in mystery and obscurity, their message is nevertheless majestic and inspiring. Only a few miles away, the highest church spire in England, the Salisbury Cathedral, stands as a symbol of the creativity, the industry, and the faith of the Christian architects and engineers of the 13th century. A visitor to that cathedral may view one of the 4 remaining copies of a famous document that was signed at Runnymede early in that century. The message to be found in the text of the Magna Carta is neither clear nor unambiguous because its language is not plain and its style and lettering are unfamiliar. It is nevertheless an important symbol because it constitutes evidence that a once powerful ruler, King John I, promised a group of his subjects that the occupant of the throne of England would thereafter obey the law of the land. The significance of King John's promise has been anything but constant. In the 2 centuries after it was made, one English king after another deposed his predecessor by means that violated the law of the land. Although Henry VII was crowned after his victory at the Battle of Bosworth on August 22, 1485, he established August 21st as the date when he had become king, thus retroactively condemning his former adversaries as traitors because they had fought to defend the then recognized occupant of the throne. In the late 16th century, when the greatest author of all time dramatized the life of King John, he did not even mention the Magna Carta. Today, at least in America, the reign of King John is remembered because of that document. In Elizabethan England, however, that great symbol had either been forgotten or at least was not viewed with any special favor by the most popular spokesman for the establishment. Today we focus our attention on another great symbol, a promise made 200 years ago that the newly created federal sovereign would obey the law in this land. We need training for the microphone installer. That promise has surely not been forgotten, but its meaning has changed dramatically during the 2 centuries of its life. To emphasize the importance and the character of that change, I have entitled my remarks, The Bill of Rights, A Century of Progress, because some of you may wonder why I refer to only 1 century and also why I refer to progress. I shall begin with a comment on my title. This important conference is a tribute to Chicago and to this great university. I am proud to be one of its graduates and to have taught briefly in its law school. The university is now 100 years old. Its participation in the development of American education, and more particularly legal education, unquestionably merits characterization as a century of progress. Just 2 years after the university was founded, the midway which adjoins this campus was the location of the famous amusement park in the 1893 World's Fair, where Little Egypt became famous for her erotic dancing. 40 years later, in 1933, the city of Chicago celebrated its 100th anniversary by sponsoring another enormously successful World's Fair, which also brought fame to a nude dancer named Sally Rand. Whether her performances were protected by the First Amendment is a question that 2 illustrious Chicago professors, who also wear judicial robes, recently debated in a case that I believe was correctly decided by the Court of Appeals for the Seventh Circuit and incorrectly decided by a confused and fractured majority of the justices of the Supreme Court of the United States. "1933 was a year in which this city, indeed the entire Western world, was in the throes of a severe economic depression. Adolf Hitler came to power in 1933, and book burning became fashionable in Nazi Germany. Chicago was then known throughout the world as the home of Al Capone, the master of organized crime who had made millions during the federal government's war on alcoholic beverages. At that time, less prosperous criminals were sometimes treated brutally by Chicago police officers seeking confessions of guilt. 1933 was the year in which the city's mayor was killed in an attempt to assassinate President Roosevelt. Before the fair opened, there were many reasons to be pessimistic about Chicago. Nevertheless, the fair was appropriately given a name that focused on the positive and inspired Chicagoans to build for a glorious future. The fair was named A Century of Progress. My selection of a title for this address reflects more than a nostalgic memory of that World's Fair. It was motivated in part by the fact that 1991 is a year in which an occasional echo of 1933 has sounded an alarming note. A volatile stock market, an ever-escalating deficit, and disturbing reports of mismanagement of major financial institutions remind us that in 1991, as in 1933, that risk is a characteristic of a free economy. The stagnation of the Soviet economy, reminiscent of Germany in 1933, furnished the setting for the attempted coup by the KGB and the military that produced frightening, though brief, memories of Hitler's rise to power and the ruthless behavior of his Gestapo. In Great Britain, 1991 is a year in which the re-examination of the convictions of alleged Irish terrorists has reminded us that trusted police officers sometimes fabricate confessions to obtain convictions. In this country, while dozens of universities and communities throughout the land are celebrating the bicentennial of the Bill of Rights, an extraordinarily aggressive Supreme Court has reached out to announce a host of new rules, narrowing the federal Constitution's protection of individual liberties. The prosecutor's use of a coerced confession, no matter how vicious the police conduct may have been, may now constitute harmless error. In a totally unnecessary and unprecedented decision, the court placed its stamp of approval on the use of victim impact evidence to facilitate the imposition of the death penalty. The court condoned the use of mandatory sentences that are manifestly and grossly disproportionate to the moral guilt of the offender. It broadened the powers of the police to invade the privacy of individual citizens and even to detain them without any finding of probable cause or reasonable suspicion. And in perhaps its most blatant exercise of lawmaking power, marching under the banner of federalism, it completely rewrote the procedural rules governing post-conviction proceedings to foreclose judicial review of even meritorious constitutional claims in capital cases. An attorney's untimely filing of a notice of appeal from a state court's refusal to grant post-conviction relief, a negligent misstep that previously would merely have foreclosed appellate review of that refusal in the state's judicial system, is now also a bar to federal review of a claim that the Bill of Rights was violated when the death sentence was imposed on the negligent attorney's client. Although the court's extraordinarily disappointing performance in 1991 can only have a sobering influence on bicentennial celebrations such as this, the work product of a single term must be viewed from a broader perspective. Even while American judges are depreciating the value of liberty, this is a time when, thanks largely to the vision of Mikhail Gorbachev, and perhaps also to the symbolic power of documents like the Bill of Rights, the voices of freedom have produced the beautiful music of debate, controversy, and progress in much of Eastern Europe. Perhaps in time, the free exchange of ideas in other parts of the world will give Americans the incentive and the courage to re-examine the reasons why our prison population, and particularly the number of inmates on death row, steadily expands at an alarming rate while armed conflict in the streets of our cities continues to flourish. The broader perspective from which the Supreme Court's recent decision should be viewed is temporal as well as geographic. My topic is intended to suggest that it is appropriate to consider the significance of the Bill of Rights during an entire century, and more particularly, to determine whether that century of jurisprudence represents legitimate progress. Prior to the Civil War and the subsequent adoption of the 14th Amendment, the Bill of Rights was merely a limitation on the power of the federal government. Arguably, the first 10 amendments were redundant because they did little more than identify some of the outer boundaries of the powers that the original Constitution conferred on the federal sovereign. In the first century of its existence, the Bill of Rights was, in some respects, comparable to the Magna Carta, a relatively static symbol expressing the general idea that the federal government has an obligation to obey the law of the land. In the second century of its life, however, the Bill of Rights became a dynamic force in the development of American law. The United States Supreme Court played a major role in that development. Its liberal, one might say activist, interpretation of the word commerce in Article 1 of the Constitution created the gateway to a vast expansion of the federal government's power to regulate the lives of individual citizens. Increased federal regulation, as well as federal participation in federal criminal law enforcement, inevitably gave rise to individual claims that the federal sovereign was invading territory protected by the Bill of Rights. Of even greater significance was the Supreme Court's determination that basic concepts described in the Bill of Rights are incorporated in the 14th Amendment's guarantee that no state may deprive any person of liberty without due process of law. The construction of the Due Process Clause, or as I prefer to call it, the Liberty Clause in the 14th Amendment, has transformed the Bill of Rights from a mere constraint on federal power into a source of federal authority to constrain state power. In this century, most of the significant cases raising Bill of Rights issues in the final analysis have actually been interpreting the word liberty in the 14th Amendment. Indeed, the impact of that amendment on the Bill of Rights has also led to an expansion of the meaning of the word liberty as it is used in the Fifth Amendment. When the court held that the racial segregation of students in the public schools in Topeka, Kansas, violated the Equal Protection Clause, simple justice indicated that the same rule should obtain in the federal enclave known as the District of Columbia. Unable to rely on the Equal Protection Clause because it applies only to state action, the court unanimously found what is now known as the equal protection component of the Due Process Clause embedded in the word liberty, as it is used in the Fifth Amendment. Thus, through the process of judicial construction, the Bill of Rights has become a shield against invidious discrimination by the federal government, as well as a shield against the misuse of state power. The judiciary's reconstruction of the term commerce during this century is generally accepted as legitimate by even the most conservative critics of the Supreme Court's work product. Respected scholars have, however, questioned the legitimacy of the court's doctrine incorporating portions of the Bill of Rights into the Liberty Clause of the 14th Amendment, as well as the decisions incorporating the idea of equality into the Liberty Clause of the Fifth Amendment. Because the Fifth Amendment has been a part of the Bill of Rights throughout its 200-year history, it is appropriate to say a few words about the latter criticism before discussing the broader question of incorporation. If the task of judicial construction began and ended with a grammatical and etymological analysis of legal text, or even if it is slightly expanded to encompass an analysis of the original intent of those who drafted and enacted that text into positive law, one would expect an impartial court to reject any claim that the word liberty, as used in the 1791 Constitution, had endorsed the revolutionary idea that all men are created equal. For the text of the Constitution in 1791, before as well as after the ratification of the Bill of Rights, expressly approved of invidious discrimination. Article 4 provided positive protection for the institution of slavery, and Article 1 provided that for the purpose of apportioning congressional representatives, each slave should be counted as 3/5 of a person. The interest in protecting individual freedom that animated the adoption of the Bill of Rights left these portions of the original Constitution untouched. The framers had constructed a document that, like the fledgling nation itself, could be described as a house divided against itself, an institution that was half slave and half free. A constitution that expressly tolerated the worst kind of discrimination could not simultaneously condemn all irrational discrimination. Those who argue that the meaning of the word liberty as used in the Bill of Rights is the same today as it was in 1791 correctly point out that the draftsman of the Equal Protection Clause of the 14th Amendment proposed no parallel provision to expand the Liberty Clause of the 5th Amendment. Because the text of the 1791 amendment has not been changed, they assume that we should simply ignore other changes in our fundamental law in the process of construing that text today. The logic of that straightforward argument leads to the conclusion that the unanimous decision of the Supreme Court in Bowling against Sharp was simply wrong, and that, as some critics suggest, the justices had arrogantly assumed a lawmaking role to implement their own notions of wise social policy. Notwithstanding the force of this hybrid plain language original intent argument, the judicial recognition of the equal protection component of the Liberty Clause of the Fifth Amendment is so well established that there is no need for judicial opinions to contain an explanation of the legitimacy of the rule. In a symposium such as this, however, it is appropriate to explain why the rule is firmly grounded in our law, for reasons that are even stronger than the doctrine of stare decisis. Just as the task of statutory construction requires a judge to examine the entire text of the relevant statute in order to understand the meaning of the provision in dispute, so does constitutional interpretation often involve a study of interrelated provisions. The changes in constitutional text that were effected by the adoption of the 13th, 14th, and 15th Amendments breathed new life into the entire document. The purge of the odious provisions that infected the 1791 text made it appropriate in the post-Civil War period to give the word liberty its ordinary meaning, indeed a meaning that is not only acceptable to today's judges, but one that presumably would have been acceptable to an 18th century jurist as well if the original Constitution had not contained those odious provisions. As the court noted in its opinion in Bowling against Sharp, it has not defined the word liberty with any great precision, though it has often made it clear that the concept encompasses more than a freedom from bodily restraint. Whether the concept is broad enough to encompass the idea of equality is a question that is easily answered by reference to the standard articulated by Justice Holmes in his Lochner dissent. Is it a matter of fundamental principle that has been so understood by the traditions of our people and our law? Perhaps the most articulate authority on those traditions was a lawyer named Abraham Lincoln. He unquestionably would have agreed with the court's conclusion that the term liberty includes a right to equal treatment under the law. For in his address calling for a new birth of freedom, he identified the direct connection between the idea of liberty that was to prevail when General Lee ordered the Confederate Army to retreat from Gettysburg on July 4, 1863, and the idea of liberty that had prevailed when the Declaration of Independence was signed on July 4, 1776. Lincoln's calculation of 77 years as the interval between his dedication at Gettysburg and the birth of the nation identifies the Declaration of Independence, rather than the Constitution or the Bill of Rights, as the source of his understanding of the term liberty. The self-evident proposition enshrined in the Declaration, the proposition that all men are created equal, is not merely an aspect of social policy that judges are free to accept or reject. It is a matter of principle that is so firmly grounded in the traditions of our people that it is properly viewed as a component of the liberty protected by the Fifth Amendment. The positive command expressed in the Bill of Rights that the federal sovereign must obey the law of the land unquestionably requires federal judges to respect the proposition to which the forefathers dedicated the founding of the nation itself. The text of the Liberty Clause of the 14th Amendment, which provides that no state shall deprive any person of life, liberty, or property without due process of law, offers a different basis for criticizing the Supreme Court's decisions applying provisions of the Bill of Rights to the actions of the sovereign states. As is true of the Fifth Amendment, a literal reading of that clause provides the individual with a guarantee of fair procedure before the state may deprive him of life, liberty, or property. But it does not, in terms, impose any constraint on the kinds of deprivations the state may impose on its citizens. Moreover, the general requirement that there must be due process, which appears in both the Fifth and the 14th Amendments, arguably should not encompass such specific guarantees as the right to a speedy trial, the right to counsel, or the right to compulsory process, because the Sixth Amendment would have been redundant if those rights were already protected by the general guarantee of due process in the Fifth Amendment. The Supreme Court has nevertheless concluded, in a long and unbroken line of cases, that the Due Process Clause of the 14th Amendment does require the states not only to comply with specific procedural protections in the Bill of Rights, but also to respect certain substantive guarantees. The court's interpretation of that clause makes some state action entirely invalid, regardless of the procedures the state may employ in enforcing its command. The most striking evidence of the court's willingness to ignore the literal meaning of constitutional text is provided by cases preventing the states from abridging the freedoms protected by the First Amendment. The text of that amendment provides, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances." A judge who strictly construes that text must find it difficult to understand how it limits the power of any governmental body other than the Congress of the United States. Even when the First Amendment is read in the light of the 14th Amendment's command that states may not deprive anyone of liberty without due process of law, the puzzlement remains. To find the solution, it is necessary to search judicial opinions. Although the earliest of the opinions endorsing the proposition that the federal Constitution protects speech and associational freedom from state action were written by two of our greatest justices, Justice Holmes and Justice Brandeis, neither of them bothered to quote any part of the text of the First Amendment to support that proposition. In his dissent in Gitlow against New York, Justice Holmes merely asserted, "The general principle of free speech, it seems to me, must be taken to be included in the 14th Amendment, in view of the scope that has been given to the word liberty as there used." 2 years later, in his separate opinion in Whitney against California, Justice Brandeis expressly endorsed the conclusion that the Due Process Clause provides substantive as well as procedural protection, and also the proposition that the term liberty embraces the right of free speech. I quote 2 sentences from his opinion to emphasize the non-textual basis for his conclusion. "Despite arguments to the contrary, which had seemed to me persuasive, it is settled that the Due Process Clause of the 14th Amendment applies to matters of substantive law as well as to matters of procedure. Thus, all fundamental rights comprised within the term liberty are protected by the federal Constitution from invasion by the states. Of particular interest is the fact that the first 2 cases that Justice Brandeis cited to support that conclusion were Meyer against Nebraska and Pierce against the Society of Sisters. Those, of course, are the 2 leading cases holding that certain fundamental rights that are neither enumerated nor expressly mentioned in the text of the Constitution are protected from substantive state deprivation. Thus, although it is familiar learning that so-called enumerated rights, those specifically described in the first 10 amendments to the Constitution, are incorporated in the Due Process Clause of the 14th Amendment, we sometimes forget that the source of the doctrine of incorporation was the product of judicial evaluation of the fundamental character of the rights at stake, rather than an analysis of the text of the Constitution itself. Moreover, as the doctrine developed, the Court unequivocally rejected the position espoused by Justice Black that the boundaries of the idea of liberty are precisely measured by the contours of the first 10 amendments. Contrary to the position he advanced in his dissent in Adamson against California, the Court has neither incorporated all of the provisions of the Bill of Rights into the 14th Amendment, nor retreated from the position taken in Meyer and Pierce that the concept of liberty includes unenumerated rights. During the past century, while the relevant constitutional text has been as immutable as the Stonehenge monument, some of the propositions of law identified by that text have changed significantly. 2 guarantees in the Bill of Rights, one procedural and one substantive, illustrate this point. The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. Unlike the English common law, which perversely limited the right to misdemeanor trials, the American right to counsel has always extended to more serious crimes. Whether the amendment merely guaranteed a lawyer to the defendant who could afford to hire one, or also protected the indigent, is a question that the text of the amendment did not answer. It seems clear, however, that the early practice in federal as well as state courts did not require the appointment of counsel unless the defendant made a timely request for such assistance. A series of judicial decisions in this century has defined and expanded the right. Powell against Alabama, decided in 1932, was the groundbreaking case. Special circumstances creating an intolerable risk of unfairness in a capital case convinced a majority of the court that the absence of counsel had made the trial fundamentally unfair. A few years later, in Johnson against Zerbst, the court construed the Sixth Amendment to deprive federal courts in all criminal proceedings of the power to take away the defendant's liberty unless he has or has waived the assistance of counsel. The court rejected the Solicitor General's argument that the failure to request counsel constituted such a waiver. The rule that was applied to state criminal prosecutions during the 1940s and 1950s required counsel in all capital cases, but not in non-capital cases unless special circumstances made the particular trial unfair. In 1963, in Gideon against Wainwright, The court overruled earlier decisions and dispensed with the special circumstances requirement, at least in felony cases. More recently, the court has extended the rule to lesser offenses. It has also concluded that the Constitution mandates that counsel be competent. The rule of law created by the last clause of the Sixth Amendment and the Liberty Clause of the 14th Amendment has unquestionably changed, while the text of those amendments has remained the same. So it is with the religion clauses of the First Amendment. Their application to the states was the product of judicial opinions that did little more than announce an interpretation of the idea of liberty that was self-evident to the justices. The complete explanation of this conclusion in the court's opinion in Cantwell against Connecticut reads as follows. We hold that the statute, as construed and applied to the appellants, deprived them of their liberty without due process of law in contravention of the 14th Amendment. The fundamental concept of liberty embodied in that amendment embraces the liberties guaranteed by the First Amendment. The First Amendment declares that Congress shall make no law respecting an establishment of a religion or prohibiting the free exercise thereof. The 14th Amendment has rendered the legislatures of the states as incompetent as Congress to enact such laws. History teaches us that these clauses were motivated by a concern about rivalry among Christian sects. The intolerance that characterized 16th and 17th century England, when royal decrees made martyrs of Edmund Campion and Thomas More, when Oliver Cromwell's Puritan Roundheads covered Renaissance art and literature with the austere blanket of censorship, and when English emigrants burned witches at the stake in Salem, Massachusetts. That intolerance was the product of competition among different groups sharing the same fundamental belief in the resurrection of Jesus Christ. In his commentaries on the Constitution, Justice Story explained that the real object of the First Amendment was not to countenance, much less to advance, Mahometanism or Judaism or infidelity by prostrating Christianity, but to exclude all rivalry among Christian sects and to prevent any national ecclesiastical establishment which should give to a hierarchy the exclusive patronage of the national government. If the protection of the First Amendment were narrowly circumscribed by the specific concerns that motivated its adoption, presumably a Democratic majority could discriminate against non-Christian religions, against agnostics, and against atheists. The court, however, has unequivocally rejected that view because the principle of tolerance embodied in the First Amendment is broader than the particular history that was familiar to its authors. Just as the right to speak and the right to refrain from speaking are complementary components of a broader concept of individual freedom of mind, so also the individual's freedom to choose his own creed is the counterpart of his right to refrain from accepting the creed established by the majority. At one time it was thought that this right merely prescribed the preference of one Christian sect over another, but would not require equal respect for the conscience of the infidel, the atheist, or the adherent of a non-Christian faith such as Islam or Judaism. But when the underlying principle has been examined in the crucible of litigation, the court has unambiguously concluded that the individual freedom of conscience protected by the First Amendment embraces the right to select any religious faith or none at all. It is the principle of tolerance that in time must provide the answer to the controversy that inflames so many of our most sincere and zealous citizens. Fueling that controversy is disagreement over the point at which a seed, to use St. Thomas Aquinas' term, becomes a human being. In Stanley against Georgia and Griswold against Connecticut, the court implicitly determined that a potential father, as well as a pair of potential parents, have a constitutional right to waste the seeds of potential life. In Skinner against Oklahoma, the court held that the state could not sterilize the defendant and thus deprive him of the right to have offspring, which is a, quote, basic liberty, unquote, because he had committed at least 2 felonies. In the Cruzan case 2 terms ago, the court made it clear that the Liberty Clause protects a woman's right to make basic decisions about the physical treatment of her own body. If a small tumor threatens her well-being, she has the right, a constitutionally protected right embedded in the Liberty Clause of the 14th Amendment, to decide whether or not it shall be removed. As a purely secular matter, if we regard a growth within her body that is no larger than an acorn as still just a seed rather than a human being, as St. Thomas did, the constitutional predicate for the decisions in Stanley, Griswold, and Cruzan inexorably leads to the conclusion that the woman has a right to decide whether to waste or to preserve that seed. That right, of course, is not absolute. Personal decisions involving the treatment of diseases, for example, must take into account the welfare of society. But while the individual choice may be influenced or even dictated by the tenets of religious faith, the majority's decision to override such a decision must be justified by secular considerations. Many Americans are sincerely convinced that the duty to protect potential life after the moment of conception is just as imperative as it is immediately after birth when a fetus becomes a person within the meaning of the Constitution. To the extent that such a conviction rests on religious faith rather than physical differences between potential persons at different stages of their development, it does not provide a permissible basis for imposing the majority's will upon the individual. The standard that should govern the judiciary in deciding whether a legislature had an adequate secular basis for interfering with an individual's decision respecting the disposition of a growth within or upon her body has been debated in a number of thought-provoking opinions. Whatever standard may ultimately be applied in answering the legal questions that are generated by the abortion controversy, the decisional process must recognize the validity of at least 3 settled propositions. First, neither a seed nor a fetus is a person within the meaning of the 14th Amendment. The meaning of that term is unquestionably a matter of federal law that cannot be modified by the actions of state legislatures. Responsible critics of the decision in Roe v. Wade, those who argue that every state should have broad latitude in regulating abortion, necessarily reject any suggestion that a fetus is a person prior to birth. Second, the justification for the legislative decision not only must be secular, it also must be rational. Theoretically, a prohibition against abortion, like a prohibition against birth control, might be justified by a general interest in increasing the population of the community or the planet. Although such a justification might make a good deal of sense after a community has been devastated by war or plague, it would surely be irrational in urban America today. Third, the constitutional issues generated by the abortion controversy cannot be entirely divorced from the topics that you will be considering during a comprehensive symposium on the Bill of Rights. For the Supreme Court decisions involving so-called unenumerated rights, such as the right to marry, the right to travel, the right to exercise dominion over one's body, and the right to decide whether to bear or to beget a child, make it clear that those rights have the same source as those that are enumerated in those parts of the Bill of Rights that are enforced against the states under the Incorporation doctrine. That source is the idea of liberty. Although that idea is difficult to define, the court has given it meaning in specific cases and controversies. On the whole, the court's decisions interpreting and reinterpreting the idea of liberty have enlarged the concept. For example, I have no doubt that the views expressed by Justice Holmes and Justice Brandeis in their separate opinions in Gitlow against New York and Whitney against California though then unacceptable to the majority, are now part of our law. The right to marry a person of a different race, or a person incarcerated in a different prison, though unmentioned in the text of the Constitution, is now protected by unanimous holdings of the Supreme Court. The general trend of these decisions raises two questions that are far more important than the wisdom or lack of wisdom of any particular holding. Do they represent progress toward the constitutional goal of forming a more perfect union? And if so, has that progress been attained by legitimate means? The answer to the first question does not depend on the means by which the change has been accomplished. It would be the same if every addition to the concept of liberty that has been produced by judicial decision had, instead, been achieved by the cumbersome process of amending the text of the Constitution. If that procedure had been followed, would we have a more perfect union today than we had in 1791? Mortimer Adler has recently suggested how that question might be answered. Although I do not endorse his suggestion that the court should wield the power to invalidate unjust legislation, even if it is not unconstitutional, he is persuasive when he argues that one's views about a just society will determine whether a change in the law represents progress. Commenting on Judge Bork's confirmation hearings, he wrote, "The nominee might even have been asked whether he thought the 18th century Constitution, allowing as it did for the disenfranchisement of women, blacks, and the poor who could not pay poll taxes, was or was not unjust. If he said that no objectively valid principles of justice enabled him to answer that question, he might still have been asked on what grounds the 13th, 14th, 15th, 19th, and 24th Amendments were adopted in subsequent years, and whether they represented progress in the direction of social justice, regression, or neither. In my judgment, no matter how one defines the just society or the perfect union that is mentioned in the preamble to the Constitution, the amendments identified by Dr. Adler, as well as the trend of decisions that I have identified this afternoon, are appropriately characterized as progress. I am also convinced that the progress in the development of our constitutional law has been achieved by legitimate means. The risk of unwise decisions is always present, and that concern is greatest when the court concludes that the strong presumption of validity that attaches to decisions made by the elected representatives of the majority has been overcome. Moreover, just as risk is a characteristic of a free economic market, so also may every expansion of individual liberty pose some additional danger for society. But risk, even serious risk, is part of the price that must be paid for freedom. Unlike their French counterparts, the framers of our Constitution wisely refused to stake the fate of the nation on the will of the transient majority. With equal wisdom, they made no attempt to fashion a Napoleonic code that would provide detailed answers to the many questions that would inevitably confront future generations. Instead, they used general language to construct a framework that would allocate decision-making powers among different branches of government. The provisions for the appointment and life tenure of federal judges were obviously designed to enable them to perform their professional tasks impartially, without fear of popular disapproval. Their duty to adjudicate cases and controversies obviously encompasses an obligation to interpret the text of the Constitution. As Justice Cardozo has reminded us, this power of interpretation must be lodged somewhere, and the custom of the Constitution has lodged it in the judges. If they are to fulfill their function as judges, it could hardly be lodged elsewhere. I firmly believe that the framers of the Constitution expected and intended the vast open spaces in our charter of government to be filled not only by legislative enactment, but also by the common law process of step-by-step adjudication that was largely responsible for the development of the law at the time this nation was conceived. That is the process that has largely eliminated the use of coerced confessions in criminal trials, curtailed racial discrimination in the selection of juries, and extended First Amendment protection to artistic expression as well as to political speech. Disagreement with a particular decision does not justify an attack on the entire decisional process. Judgments that apply principles that are embedded in the Constitution, that are supported by a candid attempt to explain the application of the principle and the relevance of prior decisions, represent appropriate developments of the law, even when neither the text nor history supplies the entire basis for the new decision. For the work of federal judges from the days of John Marshall to the present, like the work of the English common law judges, sometimes requires the exercise of judgment, a faculty that inevitably calls into play notions of justice, fairness, and concern about the future impact of a decision. The fact that such concerns play a role in the decisional process does not undermine the legitimacy of the process that for the most part has served this nation well for 2 centuries. Progress in the development of the law, to borrow again from Justice Cardozo, is neither a straight line nor a curve. It is a series of dots and dashes. Progress comes per saltum, by successive compromises between extremes, compromises often, if I may borrow Professor Cohen's phrase, between positivism and idealism. The notion that a jurist can dispense with any consideration as to what the law ought to be arises from the fiction that the law is a complete and closed system, and that judges and jurists are mere automata to record its will or phonographs to pronounce its provisions. Ideas of justice will no more submit to be banished from the theory of law than from its administration. An important protection against the unwise use of the judicial power to interpret the Constitution has its origin in common law jurisprudence. Judges have always attached less importance to dicta than to the portions of an opinion that are necessary to explain a judgment. The doctrine of judicial restraint, which counsels against the use of unnecessary dicta, also imposes on federal judges the obligation to avoid unnecessary or unduly expansive constitutional adjudication. It is of interest that Justice Brandeis is the author of the leading opinion expounding this doctrine. I refer, of course, to his separate opinion in Ashwander against the Tennessee Valley Authority, as well as the author of some of the court's most inspiring words about the idea of liberty. I quote 3 sentences from his opinion in Whitney against California to illustrate the latter point. Those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. In response to Abraham Lincoln's call for a new birth of freedom in his Gettysburg Address, the 2nd century of the history of the Bill of Rights witnessed significant progressive change in the idea of liberty. Historical and textual analyses have played an important role during that century of progress, but they did not absolutely limit the court's exercise of judgment in performing its task of interpreting the underlying meaning of a dynamic concept. Let us hope that the inability to decipher the actual intent of the architects of the Constitution, like the inability to decipher the Stonehenge text, will not prevent the exercise of sound judgment from continuing the progressive development of the idea of liberty during the 3rd century of the life of the Bill of Rights. Thank you.
Thank you, Justice Stevens, for those exceptionally powerful, thoughtful, and inspiring remarks. I'm sure they will set the tone for the remainder of this conference and set the agenda for much of the discussion to follow. I'd like to offer two observations that I think help to put this in perspective. One is that I am confident that James Madison would be comforted to know, in light of those remarks, that you are one of the guardians of those rights and liberties that he so cherished. The second, somewhat more sobering, is that I suspect with those remarks you have just disqualified yourself from appointment to the Supreme Court of the United States. Finally, I'd like to say that when I offered those introductory remarks a few moments ago, I said that we've been inundated this year with conferences and debates and symposia about the Bill of Rights. It was my belief this one is unique, and now I am certain of that, because I'm confident no other conference will be able to boast that a justice at the Supreme Court, in one speech, invoked King John, Little Egypt, Al Capone, Adolf Hitler, Louis Brandeis, Sally Rand, Abraham Lincoln, and Wally Blum. Thank you, Justice Stevens. We will reconvene in 10 minutes sharp for Property Rights and the Politics of Distrust with Richard Epstein, Frank Michelman, and Carol Rose.